I'm going to switch gears just a little bit and try to get into the technical aspects of asylum, and this will just kind of give you an idea of why this is such a difficult and sort of confusing area of law. Because again, there's nothing in the statute that says sexual orientation is a basis for relief. There are certain things that are a basis: race, religion, nationality, political opinion, and then there's this very bizarre phrase, membership in a particular social group, which even the courts are grappling with. What does it mean, social group? But even before we get to those five, there are five protected grounds. Before we even get there, you have to sort of prove other things. So I said before, an asylum seeker is somebody who's in the U.S. It's different from refugees who are processed from abroad. But asylum seekers have to meet the refugee definition, and that is somebody who cannot return to his or her country because they fear persecution or a well-founded fear of persecution, so that they suffered past persecution or they have a fear of future persecution based on one of five grounds. So you can kind of imagine persecution. Past persecution are probably some of the things that we've talked about and that you can imagine: beatings, prolonged detention, rape. Some of the courts have said, well, are threats enough? I had a client who was closeted in his home country, and then maybe a neighbor found out, and the neighbor was sending threatening letters, and then people were shouting outside his house, "We're going to kill you, we're going to kill you," but they didn't do anything. Is that enough? And again, some of the courts have found threats alone are not enough. It has to come with something. There's also some good case law. There's a good First Circuit, the circuit that we're in, good federal case that says threats alone can be persecution, but usually there has to be something else, like maybe a threat with a gun, or threats in a country, for example, in the case I had mentioned, where there is a pervasive pattern of discrimination and harm to the LGBT community. So again, you need to have physical harm, and the other thing is pervasive pattern. So even if I'm working with a client who hasn't come out and hasn't been tortured and hasn't been beaten, they need to show that there's a pattern of discrimination or pattern of persecution, pattern of harm against others that are in a similar situation. There's some things that are not persecution, like prosecution, and this comes up a lot in sexual orientation cases where you have on the books some kind of, a law that says certain sexual acts, maybe a homosexual act, is illegal. Well, say you violate that law in your home country and you're arrested or you pay a fine. Is that, in that alone, and otherwise the country is fairly accepting, is that going to be persecution? It depends. Is the punishment disproportionate? I think for most adjudicators, any kind of, a country really that's going to have that kind of law and acts on it is probably going to be able, in that country, you're going to be able to show practice and pattern. But there are times where maybe it's a minimum fine or maybe a minimum jail sentence, and that may not be persecution. Most of the cases we've seen, and in fact there's a sort of one horror story that I just read about in researching LGBT claims in Honduras, was there was an LGBT activist who was arrested, and arrested actually quite often, and he was picked up. He was charged on one of these sort of bogus, they have some kind of like moral, if you're immoral, you can be arrested, and the police use it against LGBT activists all the time, and he was actually picked up, arrested, thrown in a cell with known gang members, and beaten and raped all night. And so in that case, obviously that's not just prosecution, that's persecution. The other thing, so we have past persecution. You can get asylum if you can show past persecution, and you can actually get it if it's only past persecution. And maybe you can't show, or there's been country conditions have changed, there's no future persecution. Those cases are harder, but you actually can be granted. But the other thing to really show, and there's a presumption if you can show past persecution, that you can also establish future persecution. And that's the other thing that you have to show. Future persecution is where you sort of get into the nitty-gritty of corroborating. How do you prove? And there's actually, courts have found there's two steps. For future persecution, you have to show that the client fears returning because of harm on one of those five reasons. And you also have to show objectively, through country conditions or an expert, that in fact the person would be harmed. So they have, the client has to tell their story, has to be able to, and sometimes I've even been in interviews where the client has said, the officer knows that the client has to show future persecution, but will ask it in a way, well, can't you go live in like the village, 100 miles away? And if a client says, oh yeah, maybe I could, but he's not understanding that the client, the officer is actually talking about future persecution, he might say yes, like again, that actually 19-year-old that I was talking about earlier, that happened in that case, and I can see the officer say, but we were able to follow it up with more questions and the client clarified. But it is difficult, again, you have to, if a client is doing this pro se, it's almost impossible for them to know all this, to know what they have to show, so they may not be able to talk about what would happen if they went back. And then the other is the, sort of putting together an extensive country condition packet just to show the conditions in the home country. So you have past persecution, fear of future persecution, and then on account of. And the on account of that, I could usually spend about 2 hours talking about this group I mentioned before, right, the particular social group. This is where sexual orientation cases are able to finally be granted, because again, for years and years before the 90s, they weren't. And then in 1990, there was a very important case that was passed, a matter of Toboso Alfonso, who was a Cuban guy, who was able to show, somebody who was picked up all the time. He was on some government list as being a homosexual. He was always brought in. He was asked, like, who are your partners? What kind of acts have you committed with them? And so when he finally came, managed to come to the U.S., he was able to apply for asylum. He actually wasn't eligible because he had crimes. He got withholding, that Harder standard that I talked about earlier. But 4 years after that, 1994, then Attorney Janet Reno took the case and said, you know what, I'm going to make this a precedential case for all sort of sexual orientation-based claims. So really good development. Still a difficult area of law just because of, the evidentiary and the preparation that you have to do. Some of the problems that do come up are what I mentioned before, the challenging parts are having clients talking about sexual identity. In some countries, it's so restrictive, and even talking about sex is so taboo, it's actually hard for them to formulate it in a way that an adjudicator needs to hear. And as I mentioned before, some of it is just, again, getting over the hurdles of shame, of self-loathing, trust issues. Again, in most countries, a lot of my clients have been beaten, abused by authority figures, and now they have another authority figure sort of demanding them to tell in detail their sort of horrible stories. And then sort of finally, even if you could sort of meet all these requirements, there are certain bars to asylum, including this one-year bar that I've mentioned earlier on. In some of the cases that I've worked on, the abuse in the home country had been so severe. So for example, there was one gentleman who was gay and found out he was HIV positive in the U.S., and he had basically been raped since a very young child and into adulthood by an uncle. Then somehow from Colombia, the FARC, the guerrilla movement, found out about him, and they also kidnapped and raped him. So by the time he came here, he just, he didn't, it took him, I think, 3 years to finally apply, and then in the meantime, he found out he was HIV positive and just really collapsed. So in that case, we were able to build a really good one-year exception, and the officers have believed in it and ultimately granted his case. But again, there are still these other bars that come up. But despite all this, I would say personally for me, working on asylum cases and working with clients is one of the most rewarding and just amazing things I've ever done in my life. And you start out with a client who can't even, look you in the eyes and can't even talk about their story, and then sort of watch them slowly be empowered, find the words. I always tell them, no, you're in this country, you're not going to be judged, I'm not going to judge you, no one is going to judge you. You don't have to hide, you don't have to feel shame. And it's just amazing to watch clients find their voices and ultimately, at least in most of our cases, get granted and be able to live here and build their lives.